Knowledge is power. Information is liberating. Education is the premise of progress in every society, in every family. We have gathered here for the valedictory ceremony of 12th Nani Palkhivala Taxation Moot Court Competition 2016. I request you all to raise for the invocation song. I call upon Anantaraman, a 4th year BCom LLB student, to invoke the blessings of Almighty.
मैत्रीं भजत अखिल हृजयत्रीं मैत्रीं भजत अखिल हृजयत्रीं मैत्रीं भजत अखिल हृजयत्रीं आत्मवदेव परामपि पश्यत आत्मवदेव परामपि पश्यत युद्धं त्यजत स्पर्धां त्यजत युद्धं त्यजत स्पर्धां त्यजत त्यजत परेष्वक्रममाक्रमणम् त्यजत परेष्वक्रममाक्रमणम् मैत्रीं भजत अखिल हृजयत्रीं जननीं पृथिवी कामधुगास्ते जननीं पृथिवी कामधुगास्ते जनको देवः सकल दयालुः जनको देवः सकल दयालुः धाम्यत दत्त दयत्वं जनत धाम्यत दत्त दयत्वं जनत श्रेयो भूयात् सकल जनानां श्रेयो भूयात् सकल जनानां श्रेयो भूयात् सकल जनानां श्रेयो भूयात् सकल जनानां श्रेयो भूयात् सकल जनानां.
Thank you, Anantaraman. Now I call upon Vikas BM, a 3rd year BLLB student, BBLLB student, to present the welcome address.
Thank you, Harini. Good evening to one and all present here. It gives me, Vikas, immense pleasure to have the privilege of delivering the welcome address of the valedictory function of the 12th Nani Palkhivala Memorial Tax Moot Court Competition 2016. It has been a weekend filled with intellect, wisdom and eloquence, and to top it all off, we have 3 of the sharpest minds of our country as the judges of the final round. Mr. RSVS Pawan Kumar is from the 1987 batch of the IRS Income Tax. He has been in the Income Tax Department in various capacities in the areas of investigation, assessment, administration and vigilance. He was involved in the investigation of cases of the securities scam of 1992 and a large number of seizure and search and seizure cases. He is presently working as a Commissioner of Income Tax Exemptions in Tamil Nadu and Puducherry and supervises the administration of income tax provisions relating to charitable and exempt organizations. And this is something interesting that has been pointed out to me, and I've asked to share this with the audience. When our institution, our university, invited PR Ramasubramanya Raja, the chairman of the Ramco Group, to be a part of this event, he replied via letter to our Vice Chancellor, and he thanked us for the invitation, and I am quoting from the letter. He says, I am also happy to receive your invitation for the valediction of the above competition program taking place on 3rd April, for which you have invited doyens of the income tax, especially Shri RSVS Pawan Kumar IRS, Commissioner of Income Tax Exemptions. In my opinion, he is a large-hearted person who interprets law to help the honest and genuine taxpayers. It is very difficult to find such a person in the Income Tax Department. I am glad that you were able to get him to speak on this occasion. I think that exemplifies the character and the nature of the man we have leading the jury today. It is a pleasure to have you here, sir, and we wholeheartedly welcome you. Mr. Arvind Datar is someone who does not need introduction to tax students, especially to mooters. He is a senior advocate with an experience of over 35 years and is an expert on constitutional and tax law, having authored books and articles on both fields, which I'm sure most of the participants have referred to in their preparations for this competition. He has argued in various high-profile cases in the Supreme Court. He represented the Madras Bar Association in the Supreme Court in the case where a 5-judge bench of the Supreme Court struck down the constitutional validity of the National Tax Tribunal. Mr. Datar has also been in the limelight recently as the advocate representing the Securities and Exchange Board of India in the SEBI vs. Sahara case. It's a privilege to have you here, sir. We are completely honored and we wholeheartedly welcome you. Mr. N. Venkatraman has been a part of the Shastra family for a while now, and he has proved himself to be a valuable guide, mentor, and an exemplary source of inspiration to all the students of Shastra University. A senior advocate with over 25 years, he has argued in multiple and various high courts of the country, and he has argued high-profile cases in the Supreme Court. Mr. N. Venkatraman represented Vodafone in the Commissioner of Income Tax versus the Vodafone SR South in the Delhi High Court, and also represented Wipro in its foreign credit tax dispute with the revenue, which I think was evident from his line of questionings to the participants. It gives me immense pleasure to once again welcome Mr. N. Venkatraman on behalf of Shastra University to our campus. I would also like to humbly welcome Honorable Justice Nagamuthu to our event and to our campus. You have blessed us with your presence, sir, and we cannot thank you enough for making it to this event. I would also like to humbly welcome our Vice Chancellor, respected Professor R. Sethuraman, whose constant blessings and guidance have always been a source of strength. Further, I'd like to welcome our Dean of Planning and Development, Dr. Vaidya Subramaniam, our beloved Head of the Department, Dr. Abhishekara Raju, I would also like to welcome all the special invitees who are present here, my fellow students, and last but not the least, the participants from various institutions all over the nation who have made this event a success. Thank you very much.
Thank you, Vikas. Before we move on, I request our beloved HOD, Dr. P. Ravishekar Raju, to give away the mementos for the judges of the finals. Now, it is time, ladies and gentlemen. It is indeed an honor to call upon Senior Advocate Shri Arvind P. Datar to deliver the valedictory address on this occasion.
I must first apologize to Shastra University for taking so long to come here. It just happened that whenever Dr. Subramaniam called me, Vaidya Subramaniam called me, some reason or the other I could not make it. And so this time when he said that I'll have to judge the finals and also speak, I made it a point to be here at any cost. And I think I'm really glad that I came here. Now I regret I should have come here some couple of years earlier as well. Before I give my lecture, I must congratulate all the people who participated in the Moot competition. When I see all of you, I have no doubt, and I don't say this to flatter you, I have no doubt that there is still Achhe Din will come for the Indian legal fraternity. I only hope and pray that most of you get into litigation and don't take corporate jobs and leave the profession. Please. There's a lot of scope, a lot of necessity. There's a dire need for very competent counsel. Now, coming to my lecture, I first came across Mr. Palkhivala, Nani Palkhivala in Bombay in 1973. I was a student of the Ruya College, and we have a sister institution called the Podar College of Commerce. And he came there to deliver a lecture at the Podar College. I was mesmerized by his talk for 45 minutes, and thereafter I kept attending all his lectures at Bombay because I was there till 76. And I was also one person who's attended his lectures at the Brabant Stadium with 1 lakh people attending the budget lecture. It is something which can't be described unless you've seen it in person. Subsequently, when I wrote my excise book, I asked him to write a foreword, but he said he had no time, but he'll write a letter of commendation. But that didn't happen. But then I interacted with him a couple of times, I met him a few times and so on, but our relationship was not close. I just knew him as a senior lawyer and met him, say, 4, 5, 6 times. But I was very much in touch with the Forum of Free Enterprise and with Mr. Pai, who perhaps spent more time with Palkhivala than anybody else except Mrs. Palkhivala. He accompanied him on all the tours and travels, and I used to always ask him about Palkhivala and what made the man tick. And right from my young days, I was always fascinated by one question. What makes one person reach stratospheric levels of achievement? What makes one person achieve so much more than the other? And it so happened that just 3 months before he passed away, I was in Bombay to do a case for Vico Vajradhanti. The question was whether Vico turmeric toothpaste is Ayurvedic or not. My wife is always shocked at why we are spending so much time on whether it's Ayurvedic or not Ayurvedic and so on. But this is a matter of life and death for the client. So I spoke to Mr. Pai. I said, can I come and see Mr. Palkhivala? Because earlier I used to go to meet, I used to go to Bombay House and say hello to him. So I said, can I go and see him? He said, no, Arvind, he's in a very, very bad position, or better that you don't see him at all. This happened in October and he passed away in December. In Madras, 7 of us started the first Palkhivala Foundation, and a month later they started the Palkhivala Memorial Trust in Bombay with Mr. Surabji and Mr. Maligam and so on. After he died, the Memorial Trust requested M.V. Kamath to write the biography of Palkhivala and requested Mr. Sorabji and me to write the life of Palkhivala in the light of his cases. To put it briefly, we were supposed to chronicle his legal journey from the beginning till the end. So I was given the task, Mr. Sorabji and me, to do the legal thing, and Mr. Kamath. Of course, Kamath's book came first. He's a full-time journalist. I took much more time, and I'm told that most students in Shastra University have a copy of the book which we wrote, called The Courtroom Genius. All. And this book was released in 2012 by Justice Kapadia, who gave the Palkhivala Memorial Lecture in January 2012. It took me 7 years to write the book because part-time, but the writing of the book was a fascinating, enriching, enlightening experience. I had the opportunity to interview almost all the people who worked with him, his colleagues, his juniors, senior judges like Justice Chandrachud, Justice Venkat Chalaya, Justice Ranganathan, all those before whom Palkhivala appeared. I had the chance of interviewing, and I still got those tapes. And what fascinated me was, how did this man do so much? If you read the book by Major General Nilendra Kumar on Palkhivala, you'll find in the appendix, he has said that he did something like 345 or 350 cases, important cases in the Supreme Court, So from 1950 to 1995, he stopped coming after 95. In 45 years, the man has done 350 important cases, which is a record of 7 cases per year, which is something phenomenal. And it so happened that when I was just finishing the book, I came across Malcolm Gladwell's book, Outliers. I don't know how many of you read the book, Outliers. And he said that what makes one person reach the level of, say, M.S. Subbulakshmi or Ravi Shankar, what makes the other person a person who's at a lower level, and finally a person who's just perhaps playing music in the local village or something. And the answer, according to Gladwell, was 10,000 hours of deliberate practice. He said that it takes 10,000 hours to master a skill. So those of you who are lawyers, he said that there's a gentleman called Andrew Erickson who did studies in Berlin, and he found that the best violinists simply practiced more, that's all. The Beatles simply practiced more. They were in Hamburg and they were singing 8 hours a day, and that's how they developed their skills. So he said there's nothing very great about it, it's just that 10,000 hours of deliberate practice. And when I saw his life through interviews, I found that was the fundamental cause. So those of you who are going to achieve mastery must complete 10,000 hours of deliberate practice. He puts it very nicely. He says not that you don't become good because you practice. He says you will become good because you practice more and more, and that's all. And they found that the top violinists simply practice more number of hours per week than anybody else. Now this was the secret to success. And why I mention this is because all of you are young. Some of you are going to become the Palkhivalas of the next generation, and there is no other choice except work. Of course, in his case, I found that the work was of a very, very high order. I mean, working 6.5, 7 days a week. In fact, his brother told me the saddest part was he never took holidays. And he said that once in Hyderabad, they had gone for a case, and at that time, there was only Air India. There was no Indian Airlines. There was no other private airline. And that day's flight got cancelled. And they didn't know what to do. So the local lawyer said, why don't you see the Nehru Zoo in Hyderabad? And the man was so thrilled. And towards the end of his life, he said that I should have taken more holidays. That was only regret. But he worked phenomenal amount of hours. I mean, in my book I mentioned when I interviewed Ravindra Narayan, from 1950 to 1995, Palkhivala never entered the Supreme Court canteen. Never. He would finish his work, immediately rush back and do the next work. Behram, his brother, told me that he never went to the origin side bar library. He would start going up the spiral staircase to the tax court, finish his work, constitutional court, immediately rush back to Bombay House or his chamber and work. So that was the kind of energy. I spoke to Triti Dolly Kuka, his secretary, for many years. Sunday, she would get half a day off. 3 o'clock, she had to be at his house for dictation. Before she came in, he'll say, please take down the dictation. So his wife will say, Nani, please stop, let us sit down, let us drink a glass of water. So that was the work he had, the passion to do work. Now let me come to the topic because I've only got 25 minutes, Palkhivala and the Constitution of India. There is a wrong belief that Palkhivala was only basically a tax lawyer. I asked his brother Behram, what is the fact? He said, no. In 1950, when the Constitution first came, there were a number of cases on preventive detention. Communists were detained, and there were a lot of cases on acquisition of property. A lot of refugees had come from Pakistan. There were a lot of requisition proceedings. So he did a number of cases on constitutional law in writs in the Bombay High Court in the early 50s, apart from tax. And the luck of the man is, if you see my book, if you read that book, Chagla was the tax judge. He would finish all the appeals in the first 3 months. So 9 months, no tax work. Then the further luck was that income tax tribunal sat in the mornings and industrial tribunal sat in the afternoons. So you do tax work in the mornings and go to the industrial tribunal in the afternoon, and not many people know that he was doing extensive amount of labor work, industrial law work in the afternoons in Bombay because he had phenomenal knowledge of accounts. Again, look at the man's thing. He wanted to study accounts. He had no money. His father had a laundry. They had no money. In fact, I don't know if you know, when he wrote the first book, they didn't have money to pay the typist to type the first edition of the book. So Behram Palkhivala personally typed the entire first edition. That was the state. So they had no money. So he wanted how to study accounts. So he contacted Principal Banaji. There's a college called Master Tutorial College. It's a school, but it's called Master Tutorial College. The principal used to teach accounts. So Palkhivala used to go in the evening and learn accounts because he wanted to master accounts for taxation purposes. So now coming to his constitution, he did constitutional work in the beginning. And if you see from 1950 to 1965, the records, he has appeared in 2-3 important cases. One is F.N. Balsara's case on the prohibition law. and he appeared in the RMD Chamarbagwala case, which is on the prize-winning lottery scheme where the doctrine of severability is laid down by Venkatramaya. So that's the two important cases he argued. He lost the case in RMD Chamarbagwala, but succeeded. One other important case he argued was the Bombay Education Society, where they said that you can't study in English medium unless your mother tongue was English. So if my mother tongue is Marathi, I must study only in Marathi medium. Venkatrama's mother tongue is Tamil, he can only study in Tamil medium. Some silly law that was struck down by the Supreme Court. That was the three important cases. Now, what happened was after independence, right from 1951, the constitution was repeatedly amended. And as a student of law, 99% of the amendments came only because of the government's refusal to pay just compensation for acquisition proceedings. So you take the First Amendment, you take the Fourth Amendment, the Bela Banerjee's case, all cases, all came in the context of right to property, compensation and so on and so forth. In 1951, Shankari Prasad's case, Supreme Court said that there is no limit on the power to amend the Constitution. Under Article 368, in exercise of the constituent power, Parliament can amend anything. Now that law was the law till 1965, and by 1965, 17 amendments came, almost changing the Constitution. Worst of all was this 9th schedule to the Constitution, where once you put a law in the 9th schedule, you can't challenge it. So there would be a law which is struck down by the High Court, later it's put into the 9th schedule, immune from challenge. Then in 1965 came this Sajjan Singh's case. And all the sugar mills, the mines, etc. intervened in that case, and they wanted to say that, look, how long can you keep on amending? What is the role of the 9th schedule? And Palkhivala was briefed by Mr. Popat, who was the senior partner of Mullah and Mullah, to appear for a large number of mining companies and sugar companies. And Palkhivala one obsession was time. He would hate to waste any time. One joke told by J.B. Darachandji. Palkhivala will say, item 4, how long will the case take? 20 minutes, 25 minutes, will it come after 1 hour? So Dadaji told him, look, Nani, this is not a railway timetable. How do I know when the case will reach? Just have to wait, but he just couldn't wait. So he told Popat, I can't come to the Supreme Court and wait. When the matter is reached, you just call me, I'll rush by the early flight. Popat told him that, look, it's Gajendra Gadkar, and from the records I found that Gajendra Gadkar did not like Palkhivala at all. There was some reason he just disliked him immensely. And he said, be careful, you have to be there, otherwise he'll close the case. He said, no, nothing will happen. On the second day, when Gajendra Gadkar knew that Palkhivala was going to argue, he finished the argument and concluded the case. Finished. He said, there's no need, enough. He missed that case. What is most important is that in Sajjan Singh, 65 Supreme Court, for the first time, the judgment was not unanimous, it was 3:2. And those of you who are students of law, please read the dissenting views of Hidayatullah and Mudholkar. Hidayatullah effectively says, let's press the pause button. 17 amendments have taken place in 15 years. What are these fundamental rights? Are they a mere plaything of the majority? Can you amend it by majority prescribed in 368? Better judgment is Mudholkar, who for the first time used the word basic features. He said, are there some parts of the Constitution which cannot be amended at all? And ironically, he refers to a judgment of the Pakistan Supreme Court, Fazul Haq Chaudhry, and the Chief Justice of Pakistan was a Christian gentleman called Cornelius, a great judge. He wrote the judgment saying that there are certain essential parts of the Constitution which cannot be amended. Now, and ironically, Palkhivala's conference were half an hour, 40 minutes. He would not like to discuss more than that. But for this case, he had a 2-hour meeting with Popat, and he said that, look, you say you can amend the Constitution. Can you abrogate the Constitution? Can you delete everything? If the answer is no, then there is one portion of the Constitution which can't be touched. What is that portion? Basic feature. There's some core of the Constitution which can't be touched. And he said, Popat, we should advance this argument. But unfortunately, he could not go. But by 3:2, for the first time, Supreme Court put a question mark. Can Parliament do whatever it wants? Is it a controlled constitution? Is it an uncontrolled constitution? Where are we going? 2 years later came the Golaknath case. And as all of you know, Golaknath went the other extreme. They said that once it is part 3, Parliament cannot touch it at all. This is the... Now what was Palkhiwala's role in Golaknath? How many hours did he argue? Only 2 hours. His credit is only on prospective overruling. Palkhiwala gets no credit for Golaknath. It was done by M.K. Nambiar. And very interesting point, Palkhiwala was appearing ironically for the Union of India in Geneva regarding some civil aviation dispute. And he told Dada Chanji, I can come to India only for 1 day. I had to go back the same night. So he lands at midnight. Nariman and Ravindra Narayan brief him in the car. Next morning he goes to court and he argues on prospective overruling. Nariman told him, the Chief Justice Subbarao was mentioning prospective overruling. Without batting an eyelid, he said, you know, there's a book by Julius Stone on social objectives, social justice. There is something on prospective overruling there, but just check it. Why prospective overruling? If it was not prospective overruling, then all the amendments from 1950 would have been invalid. All the zamindari laws would have been invalid. All the land taken away would have to be given back. So Supreme Court said, our judgment is prospective. Parliament cannot amend the constitution, affect fundamental rights hereafter. So Palkhiwala's role was only on the point of prospective overruling. Now this golden period in 2 important cases, bank nationalization and the Privy Purses case. After 67, Mrs. Gandhi came to power on the platform of socialism, and at that time they said that the public sector must have the commanding heights of the economy. Just 2 days before Parliament, she issues an ordinance nationalizing 14 banks. Now why 14? Why not 16? Why not 12? They put a cut-off limit. Any bank having more than 50 crore deposits is a large bank. Just imagine how the rupee is, what is gone now. So if you have more than 50 crore deposits, it's a large bank. So 14 banks had more than 50 crores, they were nationalized. He challenged it. And I must tell you one thing, if you read, because I had the chance of reading the judgment more than once, as students of constitutional law, students of law, bank nationalization lays down 2 important principles. One, it overrode the A.K. Gopalan theory of fundamental rights being mutually exclusive. He said, no, they must all be they must be read together. So mutual exclusivity was abandoned in bank nationalization. And the second very important test which you must not forget is the object and effect test. For the first time they said, see the effect of the law, not just by what is the object. Earlier Gopalan said, it doesn't matter what the consequences, but Supreme Court said, no, you must see what is the effect. And let me tell you, in bank nationalization, Palkhiwala lost every point. Ordinance was upheld, nationalization was upheld, everything was upheld. Why did he succeed? For the simple reason that the compensation provisions were so ridiculous. In the compensation provision, if I nationalize Bank of India's assets, the value was so low, there was no allowance for the debts of the bank, only assets will be taken. Not only assets, suppose I take a house, the building of the bank, they will see what is the rent paid. 12 times the rent is the capital value. So if your house in, say, Trichy is, you're paying 5,000 rupees rent per month or 60,000 per year, 7.5 lakhs is the value of the house. House may be worth 50 lakhs, no 7.5 lakhs. The killer was, after giving some pittance of a compensation, the act said, you will get this money after 10 years. They'll give you bonds now. First of all, your 100 crore property will get 2 crores and the 2 crores will come after 10 years. That was why it was struck down. Now we come to 1971. So his role in the constitution was to get out this A.K. Gopalan and also get this object effect theory. Now we come to what I may regard as the most shameful thing in the history of our constitution, abolition of the Privy Purses. If you get a chance, I'm sure you'll have the Constituent Assembly debates. Apart from the debates, please read, all of you youngsters, please read B.P. Menon's book, Integration of States. As all of you know, the moment independence came, we had the Indian Independence Act 1947. All the princely states, if you take statistics, we had 555, a very nice number, 555 princely states. They had 28% of the area and 44% of the Indian population. Now, all had signed concordats with the British Queen Victoria and so on and so forth. So they had recognized the paramountcy of the British crown. Now after independence, what happens to the princes? What do they do? Where do they go? By that time, partition was clear. There's going to be Pakistan, there's going to be India, and because of Sir Shri there's going to be West Pakistan and East Pakistan. Under the Act, each princely state had the option of either joining Pakistan or joining India. It was given to the choice of the individual rulers. Now you know Hyderabad did not go at all. It was finally taken over by Singh. In Kashmir, he took the standalone principle, Maharaja Hari Singh, then we know what happened later. But this is what happened. But the beauty is, it was V.P. Menon and Sardar Patel who persuaded the princes and said, please join India and Pakistan depending on your contiguous states, because small states can't survive alone. You can't have your currency, you can't have your international status, so that's how they joined. Now, they all agreed to join India on certain constitutional guarantees. What are the guarantees? They were guaranteed a privy purse. The highest was paid to the Nizam, 43 lakhs and something, and the lowest was paid to the Raja of Kathiawar of 192 rupees per year. The total amount of privy purses was 5 crores. Just 5 crores. What did they give up? They gave up 12,000 kilometers of railway. Surrendered 12,000 kilometers of railway. All the houses in Delhi, those of you who go to Delhi, Lieutenant's Delhi, you'll find Baroda House is the Northern Railway Office, Hyderabad House is the Vice President's house, Travancore House is the MRTP house. So all these houses of all the princes, Palkhivala House is a court. So they were all taken over. They could keep one palace, they could keep some jewelry, and the privy purses was free. Now unfortunately what happened was, most of the privy princes were supporting Rajaji and the Swatantra Party. And let me tell you, to the credit of Pandit Nehru, repeatedly they plea that all these rulers are British lackeys, they are British stooges, we should not pay them anything. And there's a beautiful speech by Patel, Ashutosh Ghosh said, abolish it. Patel gets up in the assembly and says, look, let us not be petty. We have achieved United India only because of the cooperation, they've given up everything for us, let us not grudge this 5 crores, let us be magnanimous and keep it like that. Despite this promise, after independence, every All India Congress session there will be a call, abolish privy purses. Nehru finally stood up and said that let us not ever do it, but out of exasperation, Nehru wrote to the princes and says, please give up your privy purses. Princes said, no, I won't give it up. And when Indira Gandhi came back, she simply abolished it. That was challenged. Now, I was told by Arvind and Nani, the petition almost got dismissed. The privy purses were abolished on midnight at Friday. Palkhivala flew to Delhi. The petition was prepared in one day, filed, brought before Hidayatullah. He was about to dismiss it. After 2 hours of admission was admitted, and 3 months later, the entire privy purses was set aside and the princes were restored. Unfortunately, they re-amended the constitution on the 26th, because what the Supreme Court said is, you can't abolish privy purses by an executive order. There is a constitutional guarantee. So what to do? They remove the constitutional guarantee, which according to me is a shame, because if you have promised something in your constitution, then you can't give it up. There's a lovely book, there's a very good lecture by Fali Nariman, and he asked an important question. How could 1,60,000 Englishmen rule over 350 million Indians? The question put is that by Sir Arthur Trevelyan, who is a historian of Oxford University. Arthur Trevelyan asked the question, at the highest number of Englishmen in India at any given point of time was 1,58,000 or something, never more than that. In the police, in the army, in the plantations, in the judiciary, every put together, there were never more than 1,60,000 Englishmen all over India. How could they rule 350 million people? And the answer is beautifully put. The answer says they could rule for 2 reasons. They took no bribes and they kept their word. And it is a shame on a nation which does not keep its word. Now let me finish brief process and come to the famous Kesan Bharati case. And I got only 9 minutes more, so I'll conclude. When Kesan Bharati came, they wanted to brief Palkhivala. He said, I have no time. This case is going to go on for very long. I don't have time. So Popper told him, see, you dished us a Sajan Singh's case, now you can't drop us like this. He said, no, I'm not coming, you go and brief Chagla. So they went to Delhi Gymkhana Club. All this I'm telling you all through interviews. This is not anybody knows, but just through interviews of all his friends. So they went to, Chagla used to stay at Delhi Gymkhana Club, his wife has passed away, so he used to stay in the club. So they went to Delhi Gymkhana Club to brief Chagla. In the middle of meeting, he started going to sleep. He's already old, he was 73 by that time. So Popper told Palkhivala, this case requires, I don't know how many of you follow Hindi, he says, इस case के लिए लंबे रेस का घोड़ा चाहिए. Require a horse who can run the long distance. लंबे रेस का घोड़ा चाहिए, so नहीं चलेगा. They went to C.K. Daftari. Daftari gave a Gujarati phrase which my wife knows, which means, I do the work and somebody else earns the money, I'm not interested. Bank nationalization, Palkhivala did free, but Kesan Bharati did not do free. He earned good money for that case because he appeared for all the sugar mills and other people. So they told Palkhivala, said, Popper told Nani, you have to do it, you can't let us down. Case was starting on a Monday, 13 judges. He comes to Delhi on Saturday and Sunday morning they start preparing. And some interesting episodes I'll tell you of Kesan Bharati and then I'll go on to the review case. Who were briefing him? Soli Sorabji, Anil Diwan, galaxy of people. At the Oberoi, Palkhivala had a suite. And he would tell them he wants research done in a particular way. And by 9 o'clock in the night, all the books had to be kept outside his door. When he got up, God knows, by 8 o'clock in the morning, they used to have breakfast together. He used to be in his pajamas. And he would have read everything and he'd ask certain questions. And he had a particular sequence of doing his argument. He'd say, this is my point. For this point, I require this book, this book, this book. For this point, I want this judgment, this judgment, this judgment. And he used to get very irritated if there's a mistake in typing and so on. Very finicky about neatness, cleanliness and so on. So one day what happened was, he was arguing his case and they found out that on the third point, the books had been left in the hotel. Panic. So Sorabji asked Popper, where is the book? He said, I don't know, it's in the hotel. He said, go and get it now. So Popper comes out of the Supreme Court, there was no security at that time. Palkhivala's driver had gone away somewhere else, no car. He found one black and yellow taxi without a driver. So Popper got into the car, drove the taxi to Oberoi, picked up the books, came back, parked the car at Menton. Now it's not there. So that's how the case was completely saved and he could continue the matter. And finally, in Kesan Bharati also, ultimately basic structure was levied. In my book I mentioned in Kesan Bharati, it is not 7:6, it is 6.6:6.4. If you read Khanna's judgment, almost till Trichy is with the government. From Trichy to Tanjavur it comes to basic structure and that becomes the law of the country. The last mile he changes the whole thing. And because if you see Kesan Bharati's case, what is the point? 24th Amendment upheld, 25th upheld except for the last part of 31C, 26th upheld, 29th upheld, and the best joke is Kesan Bharati, Palkhivala never saw Kesan Bharati. He never met him. In fact, he never appeared for Kesan Bharati. The first case was Kesan Bharati. How did Kesan Bharati come? The Kerala High Court had struck down certain land reform laws of Kerala. Those people put it in the 9th schedule. So the lead matter was His Holiness Shri Kesan Bharati. Datar found out that that case has come in the list. So he rang up Palkhivala and said, look, this case has come, this is a chance to challenge all these amendments. So he filed intervening applications and so Palkhivala is basically an intervener. He never appeared for Kesan Bharati. And Andarijana told me that Kesan Bharati rang up his friend and said, why is my name coming in the paper every day? I've done nothing. So that's the scene. Then we come to a very, very unfortunate episode in our history where Kesan Bharati was sought to be reviewed. 73 they laid down Kesan Bharati. One more thing I must tell you. Another important judgment we forget is the Bennett Coleman case, where how to control the papers. So the government said no paper can have more than 6 pages. Just imagine Today the fashion supplement is 9 pages. So he said no paper can have more than 6 pages. If you want more than 6 pages, you must go to the government for permission. Then national paper, regional paper, size, etc. Like, typical bureaucratic control. So Palkhivala argued saying that this is not newsprint control, it's called newspaper control. And we all say that A.N. Ray was a person who supported the judgment. In this case, it was A.N. Ray who struck it down. That's a judgment we all miss, 73 Supreme Court, Bennett Coleman, beautifully written on Article 19(1)A. And surprisingly, ironically, Justice Matthew said nothing wrong with the newsprint control order. So coming back to 75, emergency. Palkhivala appeared for Indira Gandhi and then returned the brief. When she arrested everybody, he returned the brief. And one book you must read is Prashant Bhushan's The Case That Shook India. A beautiful account of what happened in the Allahabad High Court and how it came to the Supreme Court. And now this is the unfortunate part, and I'll conclude in just 2 minutes more. This basic structure is bothering the government. Meanwhile, after the emergency, Indira Gandhi brought out the 41st Amendment to the Constitution. What is that amendment? It said that if you are a Prime Minister, President, Vice President or Governor for 1 day, then you are immune from all criminal offences for life, past and present. So suppose I become Governor of Nagaland for 1 day, I can do anything, murder anybody, nobody can arrest me. Immunity for life. That was the amendment done. So this is how it could be misused. So suddenly one fine day, and this I have interviewed Chandrachud and everything is on tape. By the time 1975 came, out of Kesan Bharati's 13 judges, 8 had retired. So new judges were there. Ray constituted a 13-judge bench for reviewing Kesan Bharati. Matter posted on Monday. Niran Day was there, all ready to go. Then last minute they called Palkhivala. He came the previous night. Who's who appear for? Ultimately appeared for some labor association or somebody because nobody has to appear for. So he's okay, he's going to appear for some labor association. And the matter started, and by all accounts in all my interviews, and it's also recorded in H.R. Khanna's book, he says in the history of the Indian Supreme Court, those 2 days were the dates of the finest advocacy ever reached. And my records tell me, my interviews tell me, that possibly equally outstanding arguments ever in the Supreme Court were Ram Jethmalani's arguments in the Kher Singh appeal and in the Antule case. So these are the 3 classic arguments of all time in the Supreme Court. So coming back to this Kesan Bharati, matter started. So the question arose, who filed the review petition? What do you want to review? Because Kesan Bharati is over in 73, the law is, and Kesan Bharati they said, we have laid down the law, now we are sending the case back to the constitution benches to decide as per our law. So, very interesting case. Suddenly the Palkhivala said, who's asked for review? So, somebody said, no, we are not very sure about this basic structure, we thought we'll reconsider it. So Justice Beg told Mr. Palkhivala that why are you upset about it? We'd like to see, we don't know what's exactly his basic structure. His reply was, I can't believe that the Supreme Court does not understand its own judgment. He says nobody knows what is due process, but due process can't be applied. Basic structure will evolve from case to case, time to time, nothing wrong with that. What is wrong in doing that? Then he again asked, who has asked for the review? Justice Ray said, I think Tamil Nadu government has asked. And to the credit of Govind Swaminathan, who was our Advocate General, he got up and said, we have not asked for any review. J.M. Thakur got up and said, we never asked for any review. Then the other judges Chandrachud told me that they got embarrassed. Who's asked for this review? A review petition has to be filed in the registry, somebody has to ask for review. What is the ground of review? So that came at 4 o'clock in the evening. All the judges expressed to him that, Chief, this is not on. Who is doing all this? Nobody asked for review. He just kept quiet. Next day morning, the arguments were to continue. Ray just comes, all 13 judges assemble, and he simply gets up and says, the bench is dissolved. And that was the end of the review attempt. such an embarrassing thing they wanted to set aside the whole basic structure argument. And this is what has happened. Then of course Palkhivala then appeared in the Minerva Mills case, where he laid down this balance between fundamental rights and basic structure. He appeared in the Mandal case, where he was extremely harsh in the arguments. And finally his last appearance was in the session case, election case, where according to people Justice Murli who briefed him, he was not effective at all. By the time he had 3-4 strokes, and he was not effective at all in that particular case. And that ultimately ended this thing. But in balance, if you see what one man has done to preserve our constitution, in terms of, take the entire from Sarjan Singh where he couldn't appear, and this, I must also tell you about this fundamental rights case, this habeas corpus case, and I'll conclude. They wanted Palkhivala to come for the habeas corpus case. He said nothing to, why you want habeas corpus? He said, how can you have a case where people's fundamental rights can be taken away? It's unheard of. After Kesan Bharati, we can't even have such an argument. He said, who are the judges? Chandrachud, Bhagwati, Beg, Khanna and Ray. He said, I have no doubt, I'm not very sure about Ray, but I'm only doubtful about Khanna. I don't know him, he's a dark horse. He said, the very words used was, he's a dark horse. I mean, I don't know what he'll do. When the judgment came, they were at the Bombay House, and that time there was telex, there was no fax. Telex message came that Supreme Court has dismissed, saying that in an emergency, all rights can be taken away, you can be shot and there is no remedy. And to the surprise of everybody, it was H.R. Khanna who was the dissenting judge, and H.R. Khanna by virtue of dissenting lost his Chief Justiceship. That's just 2 cases which Palkhivala missed. So in the end, I think we all owe an indelible debt of gratitude to this man. Single-handedly, one-man army, he fought the Golaknath, Privy Purses, bank nationalization, Kesan Bharati, review, Minerva, Mandal, election. Just imagine what one man can do. I think it's a lesson for all of us. And as in the book I mentioned, what Abraham Lincoln said, that the lives of great men show that if one man can do it, others with equal effort can also do it. And I really hope and pray that I see within this audience future Palkhivalas of this country. Thank you.
Thank you, sir. Now, I request Senior Advocate Shri N. Venkatraman to address the gathering.
My dear well-wishers, we owe a sense of gratitude to 2 noble people, the Atma or soul of Nani Palkhivala, and to a greater degree to Arvind Datar for his capture about what Palkhivala and Constitution is for this last 35 years of his career. It was a wonderful speech, sir, for a very, very long time. It's a wonderful speech. It had emotions, it had passions, it had personal information which many of us have no knowledge about, and that made the whole speech look so lively and very, very captivating. At 50 I am motivated. Why not these children? Definitely. It was an amazing talk, and we are very, very thankful to you. On behalf of everyone, I say this with utmost sense of indebtedness and gratitude. So wonderful speech. 2 things about Naniji. Before he took bank nationalization case and the Privy Purse case, he was offered the position of Attorney General, which he refused. And he says he had true faith in our religion, true faith in the Indian spiritual system. He said something prevented me from taking that position. Had he taken the position of Attorney General, you would not have got a bank nationalization case in the Privy Purse case in the form in which it has been delivered today. So that's providence, that's something about him. And 2, the commitment, undivided attention at every point of time in doing a matter. He never took a matter easy. He competes with his own effort every time, and he succeeds and excels. If you see the graph of his 50-60 years of his professional career, who could win Palkhivala? It's Palkhivala which winning his previous effort to a better meritorious effort. This is a great challenge which he imposed to himself, and he qualified the race and won it on every occasion. These are two great distinguishing features which we need to really bear it in mind as professionals, and to whatever degree and to whatever extent you can follow, then to that extent you will travel the lane and the path and the distance which Nani ji has tread in his life as a professional. 2. He dealt on constitution, and I therefore thought I will be a little bit on being a moot court on international taxation. Let's take the very problem which has been given to all of you to debate. I would say, thanks to Lakshmi Kuran Sridharan's office, such a dicey problem where all of us pondering across the globe to find a solution to an issue of this nature. And we are really giving to them. And there is no firm, strong, one single resolution to the problem. What is the problem? In a cross-border transaction involving multiple countries, you need to tax it based on some concrete platform or principles. The broad principles of global taxations are only twofold. Either you tax on the basis of residence, or you tax on the basis of source. Developed nations tax on the basis of residence. US follows residence-based taxation. India, a developing nation, follows source-based taxation. That's exactly the problem. Somebody pays from India to an US entity for rendition of services in India, to India, not necessarily in India, but to India. And therefore, whether such a source of his income, the US entity is earning its income from India as its source. So, should US tax it or India tax it? So, Indian Income Tax Act says the source of taxation has to be India. You can alone tax. Then comes the treaty. The treaty says you can tax it on these circumstances A, B, C, and you are free not to tax it in circumstances B, C, D, E. Now, India-US taxation law says if somebody renders a service from India and gets a compensation from US as a fee for technical services, you don't have to tax it in India unless otherwise you make available the technology to the US entity which it can replicate on its own in future without having to do it, take your effort one more time. That's the law. You have a leading judgment argued by Soli Dastur in Raymond's case as a first landmark judgment in 2002, and every castle, the entire empire and castles have been built on that judgment, including the Supreme Court when it has referred in a couple of occasions. So this is the law. You have to make available the technology. Now we are debating what is make available. Suppose you send 10 intellectuals to US and then they calibrate your systems for 2 years. Can you say it is make available? Technology means it's not giving a CD. So these, whether human brain, if you pass IPR through a human brain, is it make available? That's a question we are right now debating in the Advanced Ruling Authority. And there is a direct Kerala High Court judgment which says human brain is goods. Thank God, not human beings, only the brain. So you have a judgment which stands against you. So this is the position. When it comes to India, Germany, you don't have the make available clause for FTS. If you simply render a service good enough, you have to pay the tax, you have to deduct the tax, the taxes have to be deducted at source. In a cross-border transaction, tax deduction at source virtually means a reverse charge of income tax in the Indian entity on the entire consideration on behalf of the foreign entity. Whole thing is captured to tax, unlike the domestic taxation. Fine. So you have India, US, which does not tax it. You have India, Germany, which taxes the same transaction. But the twist comes here. The problem says the US entity is incorporated in USA, but the place of effective management is in Germany. Now comes the triangular. So a third dimension is added to the problem. You have a source-based taxation in India, You have a residence-based taxation in the US, and you now have a situs-based taxation in Germany. It comes. So, residence, source, and situs. How do you resolve this conflict? Now you are known only to two permutations. Now there is a third permutation emerging. Can situs ever be a taxation point? That's the point. Now, treaties discuss and say, whenever there is a tiebreaker, it's not tiebreaker only in IPL or in 2020 or in hockey matches. You have tiebreaker rules even resolving tax disputes. So when there is a tiebreaker between source and residence, then for a company, you must follow the poem formula, the place of effective management of situs. So place of effective management will be the tiebreaker rule to decide the fate of the transaction. This is a simple formula at the first level. It's not over there. Then comes the next twist to it. You are pitted with a situs issue of poem. But the same treaties have different dissections and different carve-out in terms of its taxing powers. When two countries meet under a treaty, we must all understand taxing power is a natural sovereign power. When a country is born with it is its power to tax. So unless it surrenders it can tax anything it wants. It can be extraterritorial. There's no problem about it. Our constitution guarantees that when it comes to union legislation. It can be extraterritorial. We can also tomorrow change to residential base if we choose to do it. So the question is, you have a poem, no doubt about it, but is that all? Does the problem end there? If you understand various treaties, they have carved out an exception. Again, you have poem there, you have one more conflicting pattern or a perspective called the principle of beneficial owner. So, who is the real owner? Where does he reside? In a company, it's the place of registration, place of incorporation. So, if the beneficial owner, the problem in what has been mapped by them today is, you have a residence source conflict, and you have a poem in Germany, and you have a beneficial owner in US. So how do you resolve now? The fourth dimension. You have a residence rule, you have a source rule, you have a situs rule, and you have to also declare a beneficial owner. Now comes, how do you resolve the conflict? Can you now resort to poem alone? International taxation law stops with poem. You have to and there is no unanimity today in the world on poem. Because each country wants something or the other to say. Somebody says, I sign a contract, that is poem for me. Somebody says, I receive one bill, that is poem for me. Somebody says the entire board has to work, then that is poem for me. So there is no unanimity as such in arriving at the components of poem at a global formula level. There is utter confusion. So when you have, so what is poem for Germany? Germany has its own stand. We are not able to reach to GST. Internationally, they are not able to reach consensus on all these issues because each country wants to retain as much domain as possible, to recover as much revenue as possible within its geographical territory. That's the situation. So when you are pitted with a beneficial owner and poem, how do you resolve? The only way to resolve applying Indian law is, you can't apply GAR, you can't apply BEPS, nothing of that sort. You have to simply apply judicial GAR. Just lift the screen and find out where does the substance exist. The country in which substance exists possibly could be the country which has the power to tax. It's the only way to resolve at this point of time. I'm not saying this is the firm resolution. This is how global thinking is gradually debating all these points. Now we have reached a very important milestone at a global thought process of evolving two important concepts. One is the BEPS, another is the poem. The place of effective management and basic erosion of profit shifting. These are the two major concepts which are evolving slowly. I just spent 1 minute on BEPS because one of the contestants was right, even though not relevant to the case, it's an important principle for you to understand. there is something called a transfer pricing law which India is governed by from 2003. What do you mean by a transfer pricing law? You have a US entity, you are an Indian entity, you are exporting some services to US and you are collecting $100 from US. Because the entity which received your service is your own holding company, there is every possibility for you to migrate money out of India and retain it in US because it's the holding company. So you bring in a legislation called transfer pricing law to decide how much of profit should be taxed in India and how much should be left to the US. So it's like somebody splitting the bun. Ultimately, consultants and lawyers and courts are splitting the bun, not the participating parties in a global level. So, this is the problem. Out of $100, how much should India pay? That's a huge process. Don't understand that at this point of time. This is a transfer pricing law. In 12 years, they found it to be ineffective. So now they have said, let's not confine it to the pricing formula. Let us go to the root of the profit. Basic erosion of profit shifting. What do? A simple example will make you understand. India, from US, you are buying software directly, say $100, and you pay to the US entity, you need to pay 35% tax in USA. It's a money which USA has to receive, and 35% of it has to be paid as tax. Now what does US do? It gives that right to its own subsidiary in Dublin, in Ireland. What does Ireland do? It subleases the license right to Singapore, and Singapore supplies it to India. So $100, when it supplies directly to India, $35 have to be taxed in USA. Whereas you pay the same $100 to the Singapore entity, it retains $15, and there is a protocol in Singapore, 5 conditions. If you follow those 5 conditions, your $15 will not be taxed. It retains $15, sends $85 to Dublin. Dublin retains $20. Then between Dublin and US, there is a tax haven created. $60 is pushed into the tax haven, say Cayman Island. And ultimately, $10 reach USA. So, when this money really belongs to USA, every other entity is simply a replicating subsidiary entities. You pay directly $100, US will tax it at $35. Whereas today, $10 reach USA, and they found out globally, Apples, Googles, etc., are paying actually 3% income tax of their total world global turnover through these structures. And therefore, all your transfer pricing law is ineffective. You can always show your relationship and get away. So now they have brought out a theory, basic erosion. Intrinsically, the place where the income is earned and the economic action taking place in a particular taxing territory, that taxing territory will have the right to tax it. That's the genesis of BEPS. But you must also be aware, BEPS is not likely to go through in the present form because US Congress is opposing it. Because $90 of its action is happening outside US. So even if you migrate to BEPS, US is not going to get the entire $100. That's the challenge today for BEPS. You have 3 issues: BEPS, POEM, and permanent establishment. Germany has an issue. See, Germany is one of the biggest countries in Europe. It has the biggest stockyard. Everything is stocked in Germany and goods get conveyed to every other country. If you read the permanent establishment rules in various treaties, stock points cannot be taxed as PEs. So the whole action is happening in Germany, but not a rupee can be taxed in Germany. So it's fighting its space to say, you must attend. All these action plans are getting amended. PE is getting amended. Action plans are come. BEPS is amended. Action plans are coming up. So all this is deliberated for just 10-12 minutes with you only to suggest. This is a beautiful field, an extremely growing field, and you have reputed international universities conducting these as 1-year study for masters, and OECD has a big outlet everywhere to generate, and somebody was saying in the afternoon, OECD is for developed countries and UN is for developing countries. So on the same issues, there is clash of global thought, besides commentators and authors writing conflicting views on various critical issues. So it's an evolving field. International taxation is an extremely evolving field. So all of you should do your very best. Being in Shastra, it's my commitment that whenever I deliver a lecture and I conclude it, I do conclude with at least spending 2 minutes on talking about our Dharma and our philosophy. It's a commitment because this is one institute which gives you value system, preaches you Dharma free of cost. It is seeding you. This is one institute, the benefits of which you will never know at this point of time. You will never know, but please bite. At some point of time, when you grow as a banyan, you will not shake in your life. The seed that is sown today will stand by you after 20 years. This is one institute which believes in that commitment. All that you need as good lawyers, 2 things you try to practice in your life. Somewhere in your life, you must have the mind to sacrifice something, whatever you can afford as you progress in life. The mind to sacrifice is a very, very important message. Mahabharata, it says, if you want to restore Dharma, if you want to be on the sides of Dharma, you must have the mind to sacrifice. That's one of the morals taught in Mahabharata. And you know what Krishna asked for that as a prize with Draupadi? He gave her 2 options. You can be a good mother and rear your 5 great children at home, happily, and live happily forever. Or else stand and fight the rogues who destroyed you. Then you need to restore that. You need to destroy adharma and restore dharma. If you are ready for that battle, I am cautioning you today, you must be ready to sacrifice your 5 children. If you are ready for that, then that's a price for everything. So Krishna gives time to Draupadi, and after deliberation and thinking, she comes back and says, I will opt, I will suffer the death of my children rather than being sitting at home as a mother rearing my children, because dharma is more paramount than sacrificing my children. So this is a country which has done that. You must read Naniji there. You must read his final speeches. He says, I have lost a lot of things. I have lost faith in so many things that is happening now in this country. But still, this is a great country. It's a country which threw up everything. It's a country which was plundered. It's a country where its glory was tried to be devastated. But the country kept on surviving because we still cling and hold to the value systems and principles of Dharma. And that is what will ensure that we reach the next stage of our life properly. One message to you. Thank you so much, Dr. Vaidya. Thank you so much for all of you. It's a pleasure. The participants, the children were splendid. We only participated in the final session, but everyone at the semi-final, at the quarter, all of us are talking to each other. One simple sentence, we are spellbound. Each one who attended that particular, kudos to you. You have put your best efforts. It's immaterial who wins or who loses. The Atma of Palkhivala will always bless you. He is our Bhishma Pitabhata. So keep on taking his blessings, enrich yourself, progress in life. There's a great life ahead. God bless you.
Now the floor is open for questions. Due to time constraint, let's restrict the questions to 4 in number.
evening, sir. I'm Lavanya Lakshmi, a third-year law student. I'm addressing this question to Datar, sir. You spoke about the structure, about how the importance of basic structure and how it cannot be eliminated. But the basic structure as such undefined. There is no specific definition for something called a basic structure. Your opinion on that, sir?
It is true that you can't define what is a basic structure, but as it is said, so can't you define what exactly is due process? What basic structure means is, it is something which can't be defined but which can be understood. Now when you say, for example, if you see the judgments, secularism is part of basic structure. There is no such thing as basic structure. There are certain basic features which can't be touched upon. For example, independence of judiciary. That's why we struck down the NJC Act, secularism, the right to free speech. All these are held to be parts of basic structure or basic features, and it is said as basic feature because that is a limitation on the scope of Article 368. So you can amend the Constitution, but if you amend this, then you can't do that. And the point is this: the basic feature applies only to a constitutional amendment. One point which I have not understood as a student is why can't an ordinary law be struck down as violative of basic structure, but it's a different point. But a constitutional amendment can be challenged only on the grounds of basic structure. Otherwise you can't challenge a constitutional amendment. It doesn't apply to part 3 and so on. It's an amendment, yeah. And just for your information, in the history after 1973, the basic structure has been successful only in few cases. In Kyoto, Holland, the NJC case, L. Chandrakumar's case, and Minerva Mills. Apart from that, in most cases they are upheld. It's a very, in other words, basic feature is a very, very small sliver, very small band on the basis of which you can strike down a constitutional amendment. I may say it's difficult to define but easy to understand.
Sir, good afternoon, sir. Thank you for those lectures. So my question is, in today's world, most lawyers often have to take up a specialization, say income tax or criminal law or arbitration. There is so many technical fields. So sir, my question is, how can the system help a budding lawyer or an aspirant to develop a more wholesome attitude towards the law, like Nani Palkhivala, who had various kinds of practice? You yourself had first said that contrary to public opinion, Nani Palkhivala wasn't mainly a taxation lawyer, though his core competence lay there. So my question is, what do you think the system can do to inculcate a wholesome kind of training to a law student as opposed to the specialization or that approach? Because
I'll answer it later.
See, take the case of a doctor. You have reached a stage within your 5 fingers. For your thumb you go to X, for your little finger you go to Y. So why? Why is this happening? It's not that expertise gives you any other assurance other than economic benefits. Very, very simple bottom. Let's talk it very plainly. In fact, this is Goga Ragam, he has a very, very strong feeling about this specialization vis-a-vis generalization. Just only reflecting his thought process. You become a specialist because you need to be economically more powerful and more resourceful, and you need it, and there is an identity attached to it, and there is a progress forward path attached to it, and world is tending to think in that direction. You'll be surprised, in other parts of the globe, you have engineers with lawyer qualifications are given preference over lawyers who lack that qualification. It's a surprising combination, but it's a very, very successful combination that's emerging in the world. Have an engineering degree and then do law. It's a new thinking. 20 years, 25 years back, engineering with MBA was a combination. So specialization is now the requirement of the era. But you have to decide what you should do. You can choose to be a generalist or you can be a specialist. The option is always to that particular individual. There is no trust by the society. If you become a generalist now, if you exclude the areas of specialization and filter it and come to the non-occupied specialized field or general field, it doesn't give you the economic strength, the identity and independence which these areas give. So not many are enamored to pursue it. That's the logical finding. But you can still be there. If suppose, for example, take the case of Mr. Gurumurthy sir, who spoke day before yesterday. He gave up brilliant briefs in his life. He gave up lot of wealth. It's a sacrifice. Because he says, I have only 24 hours. I have to decide whether I should be a hardcore professional or I should integrate my philosophy with a thought which I am blessed to do, which I should do. He spends most of his time in the national mainstream. One typical example, a man who is capable chose to give it up and he has taken some other mainstream activity as his life. It's his personal choice. Nobody trusted it. Society did not, there is no social trust of getting specialized. Specialization is the era. You can always depart from that era. So it's basically your individual preference, your individual philosophy that decides whether you have to be in the general domain or in the specific domain.
One of the eternal questions which a lawyer has to face is specialize or generalize. And this has bothered me personally, and I discussed this with people also. Now I'll just tell you, since most of you are young and going to get into a career in law, the advantage of being 35 years in the bar is that you can learn from us and not make the same mistakes we did. There's a very great lawyer in Nagpur called V.R. Manohar, outstanding lawyer, and he's versatile in every branch. Trial, criminal law, civil law, appellate side, labor, tax, everything is superb. So when I went to Nagpur, I asked him, he said, look, when I was a junior, there were only 4 judges in Nagpur bench. So there was no question of specialization. Whatever work came, I had to take it up. And once I took up matter, I decided to study the whole thing in detail, and that has helped me. That is okay. So if you're in a smaller court, then generalization is possible because you can't afford to specialize for the sheer case of survival. But if you're in a large court like Bombay or Madras or this thing, then specializing may become inevitable because there's so much overlap in one particular area. If you start generalizing, you will not do justification to your brief. Now, today if I start doing anything and everything, consumer law, pollution, criminal, civil, as Venkatraman says, time is finite. So within 10-12 hours of working per day, I can't possibly do something. And if you're doing taxation, you have to read your briefs, be abreast of the law, read the latest judgment. So specialization becomes inevitable in a larger court. Now what would I tell a youngster to do? My personal view is I'm not very greatly enamored of these foreign LLMs, frankly. In fact, Palkhivala refused to go. That time it was a fashion for everybody to become a barrister. He said there is no need. I'd rather practice here. So if I ask, what should a young lawyer do if I'm asked? My advice is, well, I'm just giving advice. I always remember Oscar Wilde who said, giving advice is bad, giving good advice is fatal. So, what will I tell a young lawyer? Do 1 year of civil law, work in the trial courts, work in the municipal courts. Everybody wants to go to Supreme Court, everybody wants to do corporate law, waste of time. 1 year of civil law, if you can do 1 year of criminal law, that is worth more than all the LLMs of, it's my personal opinion. Once you get the basic knowledge of civil and criminal, then you go for your specialization, take tax. And this is the life of Ashok Sen. He was outstanding because he did these basics in the young days, and then he could take up any branch. So once you do basic civil law, basic criminal law, then you decide what is your specialization. You may like patents, you may like trademarks and so on and so forth. But then specialization is something like this. You must first do outpatient work, general work, and then you specialize in your field of medicine. But you must know the basics of medicine. That is my personal advice. And only one thing, as I said, which my senior told me and I keep telling youngsters is, once you decide to specialize, ultimately, only when you specialize you can deliver expertise, and the money you earn will be in direct proportion to the service you give, and the more you know, the more indispensable you become in that sense. So just remember one thing, once you go to practice and you decide to do, say, trademark law, then just make sure that you're the best trademark lawyer in that country. If you're going to be a cobbler, be the best cobbler in the world. That's as simple as that. But to answer Venkat, I agree with him. In the years ahead, once you know the basics, please specialize in one or two branches. Need not be just taxation. You can do taxation and company law, or like taxation and constitution, trademark and something. But keep one or two specializations. Others will be a dabbler. You must aim to be a master.
One last question, please.
Good afternoon. My name is Professor Satish Prem. I am a faculty in School of Law. So with regard, my question is with regard to the opinion that was expressed by Nani Palkhivala ji when he was the ambassador to the USA. And he had explained that the jury system that is present in the United States is a triumph of democracy and people's representation. At the same time, he opined from Nanavati case onwards, we have stripped the jury system. I would like the panel's opinion on the jury system and whether it would be feasible at any point of time to incorporate it into the Indian judiciary.
I think it's too late in the day to even think of going back to the jury system. A, because the time that is going to be taken. Secondly, I did discuss this with some US lawyers. See, what happens in the US is if the matter goes for jury, it's very expensive. It's going to cost you at least $500,000 to even think of going to a jury trial. That's the kind of expense that's involved. So keeping in mind the huge backlog of cases, the arrears, the amount of people available, I don't think the jury system is going to be feasible at all. You can deliver justice even without the jury system. And I think in many countries they have abandoned it and gone for a simple decision by a judge who appreciates evidence and decides.
Actually, if you can, the idea is, you may get into that space in the years to come. Wherever it does not involve government interface litigation, you must try to minimize it. Yesterday I was seeing one movie as I was traveling in the car. What could have ended up as an easy divorce because 20 fellows interfered with the husband and wife. The wife took a call that it's my life with my husband. So she removed 20 people out of it. And she prioritized a few things and managed to do a few other things. And in the process they reunited and a divorce was avoided. This is the moral of that story. So this is exactly the space. These are all several issues which does not involve government can be resolved through mutual talks, and a lawyer's role may become very effective in the years. This is one area where you can think of specializing. That it's going to throw up a huge opportunity in a country like us where we don't have time for these litigations to end up at some point of time.
The session is over. Now let's move on to the most awaited part of the whole ceremony. Now I request N. Venkatraman sir to distribute the prizes for the Nani Palkhivala elocution competition that was conducted on Nani Palkhivala ji's birthday, conducted by the Nani Palkhivala Memorial Trust. The second runner-up is Vishwas Bharatwaj, a first-year law student. The first runner-up is Rachanya N., a third-year law student. And the winner is Lavanya Lakshmiji, a third-year law student. The winner gets a cash prize of rupees 5,000, the runner gets a cash prize of rupees 3,000, and the second runner gets a cash prize of rupees 2,000. Sir, I also request you to give away the prizes for the semi-finalists of the 12th Nani Palkhivala Taxation Moot Court competition. NLU Odisha. I request the team SLS Noida to come up on the stage. Thank you, sir. Now I request Shri Arvind Datar to give away the prizes for the speaker, best memorial and best researcher. The best memorial goes to DSNLU Team Code T5. They get a trophy and a cash award of rupees 5,000. Now the best researcher. It goes to Arvind Kumar from DSNLU Team Code T5. He gets a cash prize of rupees 5,000 and a trophy. The best researcher also gets series barring the latest judgment from Shri Law House, Tanjavur. Now, so the best speaker's trophy. The best speaker goes to Sharon Elizabeth T2 School of Excellence in Law. She gets a cash prize of rupees 5,000 and a trophy. I request Pavan Kumar sir to give away the prize for the winners. Can we have a countdown? 10, 9, 8, 7, 6, 5, 4, 3, 2, 1. The winners are SLS Pune. I request Arvind Datar sir and N. Venkatraman sir to join them for a photo. The winners get a cash prize of rupees 50,000 and a trophy. The winners also get an internship opportunity at Lakshmi Kumran and Shri, knowledge sponsors. The winners also get a free subscription to Taxman Online for 1 year. Now, the runners of the 12th Nani Palkhivala Taxation Moot Court competition are GNLU. The runners get a cash prize of rupees 25,000 and a trophy. They also get subscription to Taxman Online for 1 year. Thank you, sir. Now, I would like to call upon Kiran M., a fourth-year BBA LLB student, to present the vote of thanks.
Well, it is said that when a person looks back at his life in the end, he would see a vision train of memories that are dear to him and matters the most. Today will be one such memory to me, sirs. A very good evening to everyone present here. I am Kiran N., the student convener of the 12th Nani Palkhivala Tax Moot Court competition. Standing here today in doubt as to whether any amount or combination of words would do justice in expressing the overwhelming gratitude I have today. At the outset, I thank the dignitaries on the stage today, Shri Palkhivala, Shri Arvind Datar, Shri N. Venkatraman, for taking time off their extremely busy schedule and gracing this occasion with their presence. It was an absolute delight to witness the final rounds conducted in the memory of the legend, Nani Palkhivala, be judged by legal luminaries of the taxation arena, and I sincerely doubt if there could be a better fitting panel of jury for this momentous event that hosted a marvelous intellectual duo. Thank you, sirs, your presence means a lot to us. I thank the Nani Palkhivala Memorial Trust for this wonderful initiative to perpetuate the memory of the outstanding jurists, and also for giving us the opportunity to be the proud host for this great event. At this juncture, I must place on record our most heartfelt gratitude for Shri Arvind Datar sir for being instrumental in bringing together Shastra University and the Palkhivala Trust, and thereby making it possible for this prestigious Moot Court competition to be conducted in our campus. We thank you once again, sir. Although Shri S. Gurumurthy and Shri Ramjit Palani sir have left campus on the preceding days, the resonance of the words they spoke can be felt around us and the conviction within, and for that we are eternally grateful to them at Shastra University. I thank the Lakshmi Kumaran and Sridharan attorneys, and in particular Shri R. Parthasarathy sir and Shri Sumit Khurana, for setting this wonderful moot problem at a very short notice of time. And in the past 2 months, despite their hectic schedule, keeping in mind that it was also the end of the financial year, they were very sweet and polite to us, and they supported throughout on the intellectual front. So thank you, sir. Thank you very much. I also extend my warm gratitude to the special invitees and also to all semi-finals, quarter-finals and preliminary round judges for making time for us and agreeing to be a part of this wonderful event. Thank you all. I must now thank the entire Shastra family, beginning with our Vice Chancellor, Professor R. Seturaman, for it is his vision that guides us through all time. I thank the Registrar, Dr. G. Balachandran, for his valuable presence and support throughout. Up next is Dr. Vaidya Subramaniam, Dean Planning and Development, who is a person I cannot thank as an organizer, for he heads the workforce here and he is the architect of this event in grandeur. But I feel obligated to extend my gratitude for being my mentor in organizing this event. I have learned several valuable lessons of management, not just management, even life from you, sir. So thank you very much for it. I would like to express my heartfelt thanks to our beloved head of the department, Dr. P. Rajasekhar Raju, for being the pillar of strength. I guess the clap says it all. For being the pillar of strength for the organizers and providing the necessary impetus for having this event a successful one. I thank the faculty coordinators, Professor S. Sanjit and Professor Satish Prem Raghuvaradhan, and all our professors for their invaluable contribution towards the successful completion of the Moot. Despite several annoyances caused by the student body, they very benevolently rendered their support throughout to us. Thank you so much, professors. The success of the event depends heavily on the quality brought to it by the participants of the various institutions. And for that, I thank all the participants for adding value to the reputation of this Moot through their excellence in advocacy and research. I thank the members of the Civil Maintenance, Electrical Maintenance and TIFACO for providing the necessary facilities and thereby ensuring that this event is organized hassle-free. I thank Shri Guru Raghavendra Caterers for providing excellent catering services. We have received overwhelming feedbacks that food was good. I thank all the sponsors, Higginbotham's Sitaraman Co., Shriram Law House, Springers, CTC Publications, EBSCO Host, Taxman, Copygoodle and Abhirami Xerox for their valuable support and contribution. Indeed, who can forget the coffee provided by Copygoodle? Last but not the least, the student volunteers and organizers. Braving several mercilessly hot days and enduring sleepless nights, meticulously working with clockwork precision for the organization of the Moot and sharing my passion for its success. I have only one word to offer and it is insufficient, I know, but here it is. Thank you. Thanks a lot. With that, I thank God Almighty for His infinite benevolence and blessings and thank you all once again.
Thank you, Kiran. Now, I request the gathering to stand up for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंधु गुजरात मराठा द्राविड उत्कल भंगा विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा दव शुभ नामे जाहे दव शुभ आशीष माहे गाहे दव जय गाता जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे।